We have allotted 15 minutes per side for the argument. Counsel, would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
So noted, Counsel. You may proceed.
May it please the Court, my name is Josh Kratz. I'm an attorney with Darby & Peel in Lake City, Florida. We represent the Crystal Bark in this matter. I think there are 4 issues for review on appeal, and the first issue is probably what the proper standard of review should be. Typically on motion to amend, it's abuse of discretion. And ordinarily, amendments liberally granted, and it is abuse of discretion to deny plaintiff's right to amend, with the exceptions of whether, for the instances of when it's futile to amend, the privilege has been abused, or it's prejudicial to the other party. The judge in the lower court found that it was not prejudicial and it wasn't abuse of privilege, and there isn't analysis of the futility argument and denied us our right to amend for that reason. Reviewing this, I could not find any case law directly on point that addressed this futility argument, and also reviewed Berman on civil procedure. He specifically states in his treatise that there is no case law on the futility argument. And the reason probably for this is that most of the time the judge would allow you to amend and then dismiss the case at that point based on a motion to dismiss. At that point, it would come up to the appellate court on a de novo review. In our opinion, it's the same exact analysis as you had here based on the futility argument. And
what were the reasons that the trial judge thought amendment would prove futile?
But he found it futile because of the economic loss rule analysis, which I feel has been the Supreme Court in this year kind of meeting case recently proceeded from their prior analysis of the economic loss rule and just combined it back to product liability. The second reason was he found that the closing agent or escrow agent, Sierra Title, owed no duty to the mortgagee in this instance, which was Ms. Barker, who we represent. The third reason he found was that the relation back doctrine didn't apply, so the statute of limitations had run on our action, and we were not allowed to amend. We feel that a duty is owed to the mortgagee. I know 50 to 75% of my practice is doing closings. When I get that money, typically the person who the money goes is the mortgagee. So I think to sit there and say, I don't know a duty to this person, I don't know what would keep me from absconding with the money, which is what we feel like happened here, and that's why we amended our
if we put aside the last two you discussed, go to actually the first two aside, to the last one you mentioned about the relation back, that seems to me where you have the biggest hurdle, because it's not clear to me that the trial judge made an error in saying these aren't the same or similar incidents, that really they have a couple of different transactions going on here. And so talk about that a little bit. Convince me that there's something.
Well, I think you should take a narrow interpretation of the relation doctrine, back doctrine, and look at how the defendants have framed it. It wouldn't apply, but the way we look at it is it's to be liberally interpreted. That's what the Fabiano and some of these other cases state.
Well, can I ask you preliminarily, if it doesn't relate back, do you concede that it's barred by the statute of limitations?
Yeah, absolutely. I mean, the statute headline, that's why we. But the reason it relates back is because this whole issue revolves around Ms. Barker loaning money on a note and a mortgage to D.R. Hamilton. The whole case has been about, to simplify it, I want my money back. So that's why we sued initially to get the foreclosure. Actually, there was a summary judgment granted of foreclosure, at which point we learned there were people living on 20 to 65 acres that were foreclosed on. That's when an amendment was made to add those parties. As we went on down the road, we later learned the reason that there was no release, that the folks were living on 20 acres, was that a release was not granted underneath the mortgage that Barker was entitled to. And Sierra actually contacted Ms. Barker and asked for a release for a lesser dollar amount. She declined to grant that release. Never heard back from Sierra. Thought the matter was over with. Well, she may have not responded, but I don't think she had any duty to respond. She had a contractual right under the note and mortgage to get a release for roughly $52.50 an acre. They wanted to give, this was 3 or 4 months after they did the initial note and mortgage, and and then Sierra came to her and wrote her a letter, and she didn't respond to the letter. But I don't think she had a duty to respond unless they sent a letter saying, we're going to pay you $52.50 an acre.
All right, but the foreclosure relates to the sale to DNR.
Correct.
And then the claim against Sierra Title relates to DNR sale to the Hardens.
Correct. There were a couple of transactions with DNR and the Harden, or with Sierra Title and Barker. Barker initially, when she did the loan to DNR, Sierra handled that transaction.
But you're not complaining about anything Sierra did
No,
in that?
No, I guess the reason I mentioned that is that Sierra had acknowledged that this release clause existed in the mortgage.
Which is why they wrote the letter.
Right. I mean, what it boils down to, if you interpret it broadly or liberally, the relation back doctrine, and say, well, the note and the mortgage, and she's trying to recoup her $105,000, they're all part of the same transaction, then I think we go forward. If not, I think we're going to lose on the issue. It's whether it's...
What do you do with the Graney case?
I didn't hear you.
What do you do with our decision in Graney?
I'm not familiar with that thing.
Well, I think that was a case where, as here, a defendant had brought in a third-party defendant, but the plaintiff was not allowed to amend the state of claim against the third-party defendant directly. Isn't that analogous to what we have here?
Well, that is analogous. I would just say, I'm not familiar with that case, but I would say the same claims we're trying to bring against Sierra have already been brought in the case by the defendants against the third-party defendants.
Do we know what happened as to those third-party claims?
Nothing's happened. It's still, trial is still in the future. And there's been new counsel appointed in those cases, and I think there was a trial set for September, but I imagine it will be moved to a later date at this point.
All right, can you talk to us briefly about the duty you think Sierra had to Crystal Barker?
Well, I think there are no existing cases that say the closing agent owes a duty to the mortgagee. There are cases that say the closing agent owes a duty to the principal parties of the transaction. Our position is the mortgagee is a principal party to the transaction. In this instance, she's the one to whom the majority of the money was going to be paid to get a release from the mortgage. And, when we open, I do 50, like I said before, 50 to 75% of my practice is closings. When we open that file, right there it says seller, buyer, mortgagee, because that's the person who we have to deliver the funds to. And I think for them to sit there and say they don't owe a duty to the mortgagee, it's just to stick your head in the sand.
Counsel, going back to the Graney opinion, in that case, this court noted that relation back should only be committed where there is a mistake or misnomer in identifying a party defendant, not a mistake in failing to add a party defendant. Assuming that's the case, how would you propose to get around that?
Well, this party's already been added. We're not adding the party. They've been in the case not from day one, but from pretty close to day one. Once we set aside that initial foreclosure sale to add the defendants that were living on the 20 acres, they then, third party, brought in the Sierra Title.
So who brought in Sierra Title first?
We call them the Hardens. They're the folks, they're a group of 5 or 6 individuals that are all family members that bought the 20 acres and built a home on it.
So at the time your client was trying to bring this claim against Sierra, they're already a party.
They're already a party.
Third party,
Already a party. Not only already a party, but the same exact causes of action have already been alleged against them. And, I would say, we didn't know initially why there was no release granted or what the problem was. We got on down the road in litigation, we took the deposition of Sierra's principal. He testified at the deposition that this is 1 in a million instances when the transaction was screwed up or something to that effect.
Okay, your client got all the money that she was entitled to under the agreement. You're just complaining about attorney's fees and prejudgment interest, right?
Correct. But over the course of 5 years, on $105,000, that adds up to a substantial amount of money. But I'm going to take a seat. Thank you.
Thank you, Counsel.
Good morning. May it please the court, my name is Shelby Steerick, and I represent Sierra Title LLC in this appeal. Our position in this appeal is very simple. The trial court's decision to deny Mrs. Barker's motion to amend should be upheld in this appeal. The trial court did not abuse its discretion in finding that amendment would be futile. The trial court correctly concluded that the statute of limitations had run, that the relation back doctrine did not apply, and that my client did not owe a duty to Mrs. Barker in connection with the transactions upon which the amended claims are based. I'm going to talk to you first about my statute of limitations argument. Counsel conceded that the claims were brought after the statute of limitations had expired, well after, in fact. So the only way that these can survive is if the relation back doctrine applies, and it's our position that doesn't. Simply put, the claims that are set forth in the proposed amended complaint do not arise out of the same transaction, occurrence, or conduct that's set forth in the original pleading. And that's what's required under the case law, and that's what's required under the Rule 1.190. As you all have noted, this case involves 3 separate, distinct transactions. They occur at different times. They involve different parties. They involve different documents. Although the appellant is acknowledging that there were different transactions, her argument is that all of the claims arise out of the mortgage, and therefore the amended claims should relate back. And our response to that, I actually have a couple of responses to that. First, I'm concerned about the argument that the claims against Sierra arise out of the mortgage. The mortgage is a contract, and my client's not party to that contract. My client has no responsibilities or obligations under that contract. Secondly, and perhaps more importantly,
apparently your client thought there was some, if not obligation, some need to write a letter to Ms. Barker.
That's right, Judge. My client closed, he handled the second transaction, which was the sale from DNR to the Hardens. That letter was sent in furtherance of the completion of that transaction, pursuant to duties that he owed to those people, DNR and the Hardens. The mortgage was part of the first transaction, the sale from Barker to DNR. Mrs. Barker's claims against Sierra did not come into existence until the second transaction was completed. And that is her position, her own pleadings, and her own briefs. Her claims against Sierra are based upon Sierra's alleged breaches, which occurred in the second transaction. And the alleged breaches are, you completed the second transaction without getting a proposed partial release for me, and without making sure that I was paid the release price under this contract. So we've got the mortgage over here as part of the first transaction, and then we've got the alleged breaches over here as part of the second transaction. These claims arise out of completely distinct events. In addition to the fact that they don't arise out of the same transaction or occurrence, they also don't arise out of the same conduct, which is contemplated under the rule. The earlier versions of the complaint all arise out of DNR's act of not paying the mortgage. Conversely, the amended claims arise out of Sierra's alleged failure to obtain the release and ensure that the release price was paid. The relation back doctrine does not apply in these circumstances.
Well, as Judge Bennett was saying earlier, this is the Graney case, which is Graney versus Caduceus Properties, 91-7-3-220. Which is pending review at the Florida Supreme Court because it conflicts, our decision conflicts with the 5th BCA's on this point. And the 5th BCA's case, the Gaddens case, as I read that case, you may lose in this appeal because Graney basically requires us to follow Graney, which says the relation back doctrine is more narrowly construed. I guess my question is, under the Fifth District's rationale, because your client was already a party, already within the jurisdiction of the court, under the Fifth District's opinion, as I read it, statute of limitations is basically told as to your client, and the limitations period wouldn't be running.
I understand your point, Judge, and Mrs. Barker has made that argument also. She's saying, hey, I'm not adding a new party. I'm not adding a new cause of action. Because Sierra is already defending a third-party action filed by the Hardens, which is based on a theory of negligence, and they're already defending a cross-claim filed by MERS, which is based on a theory of breach of fiduciary duty. So what's the problem? The problem with the argument is that Rule 1.190 requires that the amended claims arise out of the same transaction, occurrence, or conduct as is set forth in the original pleading, meaning the original pleading of the party that is seeking to amend. And the Fabiano decision, which both parties have cited in their briefs, states that that rule is grounded in the notion of fair notice, where the original claim provides fair notice of the factual underpinning for the amended claims will relate back. That's not the case in this situation. Mrs. Barker did not apprise my client of the fact upon which she intended to sue Sierra Title until 5 years after the fact. Yes, there's a third-party action pending. Yes, there's a cross-claim pending. However, those claims, the third-party action gives Sierra Title fair notice of the factual underpinning of the Hardens claims. The cross-claim gives Sierra Title fair notice of the factual underpinning of MERS claims. These third-party actions and cross-claims do not give Sierra Title notice of the factual underpinning of Mrs. Barker's claims. And Mrs. Barker also relies heavily on the Fabiano versus Demings case, and I would certainly agree with her that that case sets forth the standard by which it is determined if the relation-backed doctrine applies. However, none of the criteria of Fabiano is met in this case. Fabiano states that in order for the relation-backed doctrine to apply, the claims have to involve the identical act, the identical injury, and the identical damage. That is not the case here. The earlier versions of the complaint, in the earlier version...
You don't think the claims by the defendants against the third-party defendants should have been allowed?
I'm sorry, whose claims against who?
The defendants' claims against your client.
Mm-hmm. You mean the Hardens?
The third part, right, and MERS. Your position is those were improperly allowed?
No. Those were brought within the statute of limitations. But in the Fabiano versus Demings case...
But do they relate to the transaction occurrence and conduct of the main case? So long as you don't have a statute of limitations problem, I don't think that an inquiry as to whether they arrived at the same transaction, occurrence, or conduct is necessary. If you're operating...
Well, not the insurance relation back, will not be an issue or problem. If it's brought within, the claim is brought within the statute of limitations.
Yes. If the claims are brought within the statute of limitations, then we wouldn't be having this relation back discussion. It wouldn't...
So you think the cross claims can be made against anybody for any reason?
I think that a cross claim can be brought against another party relating to issues that arise from different transaction occurrence or conduct, so long as you're operating within the statute of limitations.
Counsel, going back to the Granny opinion, are you familiar with this court's opinion?
I am not, Judge. As I was saying, in the earlier versions of the complaint, the relief that Mrs. Barker is seeking from, the relief that she was seeking was a foreclosure judgment, a deficiency judgment if necessary, fees and costs. The relief that she's seeking from Sierra is completely different. She's seeking payment of the release price and lost interest on the release price. Fabiano also requires that amendments...
She's got the release price.
Yes, she has. She has since been paid the release price. Fabian, it also requires that amendments and original pleadings arise out of the same general factual situation. That's not the case here. In the earlier versions of the complaint, Mrs. Barker sets forth the facts that are necessary to establish a cause of action for foreclosure. She alleges, I own a piece of land, I sold it to DNR, we entered into a mortgage, they didn't make the payment, here's a list of other people that have some right and title on the property that's a fair crime. In her...
Part of the payments they didn't make were the payments due when they sold 20 acres.
I'm sorry, Judge, was...
Part of the payments the mortgagor failed to make was what was due when they sold the 20
Exactly,
acres.
and that was never alleged in any of the earlier versions of the complaint. In her proposed amended complaint, where she's bringing things against Sierra, at that time, she sets forth new facts regarding the release clause, Sierra's knowledge of the release clause, the fact that the second sale was concluded without her being paid the release clause and without a partial release of mortgage being obtained. At no point in any of the earlier versions of this complaint, of which there were 4, did she ever allege any facts related to that release price, the release clause, or being owed any money under that release clause. So,
All right, so they're complaining about the inability to state a Fourth Amendment complaint and bring in a new defendant beyond the running of the statute.
Right. Yes, sir. So what Mrs. Barker is essentially trying to do now with her proposed amended complaint is state, new cause of action here based on an entirely new set of operative facts, which she can't do. Regarding the, actually in summary, that is our position on the statute of limitations issue and the relation back doctrine, and we believe that the trial court did not abuse its discretion in finding that amendment was futile based on the statute of limitations. Regarding the no duty argument, this is a separate argument. We believe that either of these arguments...
You can see the economic laws were reclaimed.
Absolutely, Judge. The law has changed. We can see that the doctrine no longer applies. But we do think, that being said, that we've got 2 remaining sound arguments, either of which standing on their own would justify upholding the trial court's decision. Regarding the no duty argument, very briefly, as you've all noted, these alleged breaches on the part of Sierra are alleged to have occurred in the second transaction. Mrs. Barker was not party to that transaction. She had no role in that transaction. She reposed no degree of trust or confidence in Sierra in handling that transaction.
Well, what about his hypothetical? What if Sierra had just taken the money that the buyer and seller thought were going to go to the mortgagee and left the country? No breach? She still is able to recover that money from the people that actually bought the property, which is what ended up happening. And I would think if you're absconding with money and running off to another country, I don't know, maybe there's some criminal recourse. But, the argument that's being made that, hey, Sierra, you owed a general duty to all the principal parties to this transaction is fine, but the problem is that there is no authority that I'm aware of, none that's been presented by Mrs. Barker, which would suggest that she was a principal party to that second transaction, that someone who is neither the buyer, the seller, nor the buyer's lender is a principal party to the transaction. Again, the argument... What was the sales price on the 20 acres?
Frankly, Judge, I am not sure offhand.
If I heard correctly, the opposing counsel said most of the money was intended for the mortgagee.
I think that there's been no evidence submitted in this appeal as to what the intent was of the Hardens and DNR as to how this transaction was being handled. My client's only duty was to carry out the agreement that was between DNR and the Hardens. Again, the communications regarding the proposed release My client did send a proposed release to Mrs. Barker. She deposed Mrs. Barker. She testified that she received the release. She reviewed it. She independently determined that the proposed release did not comply with the terms of the original mortgage. She decided on her own that she was not going to sign it, and she was going to throw it away, and nothing else was required of her. This isn't a situation where Mrs. Barker called my client on the phone and said, what should I do? Please advise me. Give me some advice. It is a fact that my client provided no services or information to Mrs. Barker that she relied upon in connection with the second transaction. They provided her with no information that induced her to do something or refrain from doing something in the second
It looks
transaction.
like they voluntarily undertook to protect her interests.
I'm sorry, Judge, I disagree. I think that they sent her that letter and furtherance of the duties that they owed to GNR and the Hardens, not pursuant to a duty that they owed to Mrs. Barker. And in summary, regarding to in pertaining to the no duty argument, again, we would just submit that the trial court did not abuse its discretion and find that amendment would be futile based on the fact that there was no duty in regards to those transactions. And we ask that you affirm the trial court's decision. Thank you.
Thank you, Counsel.
One issue I'd like to address on rebuttal would be this idea of fair notice. It seems to me that the heart of the relation back doctrine is fair notice to the other side. And I don't know how they couldn't have fair notice when they've already been sued with the same exact claims. Literally negligence and breach of fiduciary duty.
So you're saying they had fair notice, just not from the plaintiff?
Just not from the plaintiff. And they had fair notice within the statute of limitations.
See, I think that's where you run into this case, which binds us, and which the Supreme, for the time being, the Supreme Court may flip it.
Well, we're not familiar with either one of us with the great case.
I think it came down after the briefs.
Okay.
So here's a little.
Well, that's the thing I really want to get